Case 1, Jessica Trefethen, June 20th, 2021, Waldo County, Maine. There are moments in a criminal investigation when the facts themselves refuse to be explained away. When the evidence is so clear, so undeniable, and so devastating that even the most experienced law enforcement professionals find themselves pausing, not from confusion, but from the weight of what they are looking at. The case of Jessica Trefethen is one of those moments. It is a case that began with a mother walking through the doors of a hospital, carrying her 3-year-old son. It ended with that child gone, a courtroom verdict, and a sentence that will keep his mother behind bars for nearly 5 decades. Maddox Williams was 3 years old. He was at the age where children are beginning to speak in full sentences, where they are learning the names of colors and animals, where they run toward the people they love with their arms open wide. He was at an age when the entire world is still new and the adults in his life are supposed to be his shield against everything frightening in it. Maddox deserved every one of those ordinary childhood moments. What he experienced instead became the subject of a criminal prosecution in Waldo County Superior Court, a case that the state of Maine pursued with everything it had and ultimately won. On June 20th, 2021, Jessica Trefethen arrived at Waldo County General Hospital in the town of Belfast, Maine, with Maddox unresponsive in her arms. Emergency medical personnel responded immediately. Despite every effort made by the medical team, Maddox Williams did not survive. He was pronounced deceased at the hospital. He was 3 years old. What followed was a methodical, court-documented medical and forensic review. The medical examiner's findings, later introduced into the official court record in Waldo County, revealed injuries of a severity and pattern that medical professionals and investigators immediately recognized as characteristic of what the medical and legal community refers to as battered child syndrome, a documented clinical pattern established through decades of pediatric medicine and forensic pathology that describes the constellation of injuries found in children who have been subjected to repeated, deliberate physical harm over time. The findings in Maddox's case included a fractured spine, a ruptured bowel, and internal injuries consistent with repeated and severe trauma. These were not injuries from a fall. They were not the result of an accident. The court record made that unambiguously clear. Investigators with the Maine State Police and Waldo County authorities moved quickly. The evidence gathered from the medical examination, combined with investigative work conducted in the weeks that followed Maddox's death, pointed directly to Jessica Trefethen. She was arrested and charged in connection with her son's death. The charge brought against her was depraved indifference murder, one of the most serious classifications under Maine criminal law, reserved for cases in which the prosecution can establish not merely that harm occurred, but that the person responsible demonstrated a profound, conscious disregard for the life of another human being. The trial that followed in Waldo County Superior Court was not a brief proceeding. The prosecution built its case systematically, relying on the medical examiner's testimony, the findings introduced through forensic and investigative evidence, and the documented condition in which Maddox was found when he was brought to the hospital. The defense had an obligation to challenge that evidence as vigorously as the law allows. But the jury, having heard all of it, every piece of evidence on both sides, returned its verdict. In October of 2022, Jessica Trefethen was convicted of depraved indifference murder in the death of her son, Maddox Williams. The verdict was unanimous. The court subsequently sentenced her to 47 years in prison. Under Maine sentencing guidelines, that number is not a suggestion. It is a wall. Jessica Trefethen did not accept that outcome quietly. Her legal team pursued an appeal, arguing that the conviction should be overturned. That appeal was reviewed by the Maine Supreme Judicial Court, the highest court in the state, the court of final review for criminal appeals in Maine. The justices examined the record. They reviewed the arguments submitted by both sides, and they denied the appeal. The conviction and the 47-year sentence were allowed to stand in full. Maddox Williams will never know that the system fought for him. He will never know that a jury of 12 people in Waldo County, Maine, sat in that courtroom and listened, and decided that what happened to him mattered. He will never know that the Maine Supreme Judicial Court reviewed the record and affirmed that accountability was the right outcome. But the record now exists. His name is in it, and the sentence imposed in his case sends a message that the state of Maine intends to protect its children, even when the people who should have protected them most were the very people who failed them. Child safety and the protection of vulnerable children remain priorities not only in our courts, but in our communities. If you have concerns about the welfare of a child, the Child Help National Child Abuse Hotline is available at 1-800-422-4453, 24 hours a day, 7 days a week. If this case moved you, if it reminded you why this kind of documentary journalism matters, please take a moment right now. Like this video, leave a comment below, and hit that subscribe button so you never miss an episode of Cold Case Hour. We are just getting started. Case 2, Sharon Carrillo, February 25, 2018, Waldo County, Maine. There is a particular category of criminal case that challenges even the most experienced investigators. Not because the evidence is hidden, but because the reality of what occurred is so far outside the boundaries of what we expect from the people entrusted with a child's care that the mind initially resists accepting it. The case of Sharon Carrillo and the death of 10-year-old Marissa Kennedy is that kind of case. It is a case documented extensively in Waldo County Superior Court records, covered by Maine media from the time of the child's death through sentencing, and ultimately resolved with convictions that the judge described as reflecting the most profound failure of parental duty imaginable. Marissa Kennedy was 10 years old. She was a child who should have been going to school, making friends, learning about the world, and being protected by the adults in her home. Instead, the evidence introduced at trial and through the subsequent legal proceedings in Waldo County established something that took investigators, child welfare professionals, and the general public a long time to fully process. Marissa had been subjected to a pattern of daily abuse inside the home she shared with her mother, Sharon Carrillo, and her stepfather, Julio Carrillo, a pattern that prosecutors established in court had continued for months. The timeline documented in the court record is specific. The abuse that investigators confirmed through evidence did not occur once and escalate. It was systematic. It was daily. And it ended on February 25, 2018, when Marissa Kennedy did not survive what was done to her that day. What Sharon and Julio Carrillo did next, after Marissa's death, became a significant part of the prosecution's case. Rather than contact emergency services, the couple staged the scene. They attempted to make it appear that Marissa had suffered an accidental fall down a staircase. It was, the evidence ultimately demonstrated, a deliberate effort to obscure what had actually happened inside that home over the months preceding February 25. Investigators were not deceived. The medical examination of Marissa's injuries told a story that was entirely inconsistent with an accidental fall. The pattern, nature, and distribution of the injuries she had sustained were consistent only with what the medical examiner and the prosecution described in court as prolonged, intentional harm. Sharon Carrillo and Julio Carrillo were both arrested and charged. The prosecutions proceeded in Waldo County. In December of 2019, Sharon Carrillo stood trial and was convicted of depraved indifference murder in the death of her daughter, Marissa Kennedy. The jury found that Sharon Carrillo had not merely failed to protect Marissa, she had actively participated in what was done to her child. The court sentenced Sharon Carrillo to 48 years in prison. Julio Carrillo's case resolved differently, though no less severely. He entered a guilty plea, acknowledging his role in Marissa's death. The court sentenced him to 55 years in prison, a longer sentence that reflected the prosecution's assessment of his culpability and the judge's determination that the full weight of accountability should be applied to both individuals responsible for what happened to Marissa Kennedy. The aftermath of this case extended beyond the courtroom. Marissa Kennedy's death, coming so close in time to the death of another Maine child, Kendall Chick, whose case we will examine shortly, sent a shockwave through Maine's child welfare system and through the public conversations happening at the state government level about how children in Maine were being protected, or in too many cases, not being protected. Legislative hearings were held. The Maine Department of Health and Human Services faced direct scrutiny. The question being asked in Augusta and in communities across the state was clear and urgent. How does this happen? How does a child suffer for months without anyone intervening? Those are questions that Maine's institutions have continued to wrestle with in the years since. The answers are complicated. The accountability, in the case of Sharon and Julio Carrillo, was not. The courts in Waldo County delivered it with clarity and force. Marissa Kennedy was 10 years old. She deserved decades more of life. The 48 years that Sharon Carrillo will serve in a Maine correctional facility are the legal system's answer to what was taken from her. It is not restoration. It cannot be. But it is accountability, applied in full, by a court that understood exactly what had occurred inside that home. If you believe a child may be in an unsafe situation, please do not hesitate to contact the Child Help National Child Abuse Hotline at 1-800-422-4453. That call could be the most important one you ever make. If you are watching Cold Case Hour for the first time, welcome, and please subscribe. If you have been with us, you already know why this work matters. Like this video, share it, and leave a comment. Every action you take helps this channel reach more people and tell more stories that deserve to be told. Case 3, Lee and Daigle, December 6, 1985, Aroostook County, Maine. Some cases sit unsolved for years. Others sit unsolved for decades. And then there are cases that remain open so long that the technology required to solve them did not exist when the crime occurred. Cases that could only be resolved through scientific advances that would not arrive until an entire generation had grown up and grown old. Cases that required not just persistence from investigators, but a leap forward in human knowledge that no one involved in the original investigation could have anticipated. The case of Lee and Daigle, and the infant known for 36 years only as baby Jane Doe, belongs to that final and most extraordinary category. It is a case that began in the bitter, bone-deep cold of a Maine December in 1985 and found its legal resolution in an Aroostook County courtroom 38 years later. A resolution made possible by a field of investigative science that was, in 1985, still decades from existence. To understand the full weight of this case, it is important to understand the geography and the context. Aroostook County is the northernmost county in Maine, and by area, one of the largest counties east of the Mississippi River. It is sometimes called simply the county by the people who live there, a testament to its scale and its identity within Maine. The communities of Aroostook County are separated by long stretches of forest and farmland. The winters are brutal, not merely cold in the way that coastal Maine winters are cold, but genuinely, severely, dangerously cold, with temperatures that regularly drop well below 0 Fahrenheit and wind chills that make even brief outdoor exposure hazardous. Frenchville is a small town in the St. John Valley region of Aroostook County, situated near the border with Canada, where the communities are historically Franco-American and deeply rooted in the agricultural traditions of the region. December 6, 1985. The temperature in Frenchville had dropped well below 0. In a secluded gravel pit outside of town, removed from any home, away from any traveled road, in a location that was isolated and difficult to access in the conditions of that winter night, a newborn infant girl entered the world. She was born alive. The medical examination conducted decades later would confirm that. She was a living child when she was placed in that gravel pit, and she was left there. The following day, a neighbor's dog was doing what dogs do, exploring, moving through the landscape, following a scent trail. The dog led its owner to a location in the gravel pit where, in the frozen ground, the body of a newborn infant girl was discovered. She had been alive when she was placed there. The sub-zero temperatures and the exposure to the elements overnight had taken her life. She had no name. She had no birth record. She had no clothing to identify her origin. She had no one who came forward to claim her, to acknowledge that they knew who she was or who had given birth to her. Law enforcement gave her the designation that investigators use for unidentified female victims, baby Jane Doe. And the investigation into who had abandoned her in that frozen gravel pit in Aroostook County began. That investigation, conducted with the forensic tools available to law enforcement in 1985, was thorough within its limitations. Investigators interviewed community members. They looked for any woman who might have been visibly pregnant and was no longer. They examined what evidence was available at the site. But without a name, without a witness who came forward, without a birth record, and without the genetic science that would later become the cornerstone of cold case investigations, investigators in Aroostook County found themselves unable to identify the mother. The case remained open as an unsolved homicide. Baby Jane Doe was laid to rest, given a burial by the community that had found her, because she deserved at minimum that dignity. Her identity remained unknown. The file stayed active in the sense that cold cases always do, referenced occasionally, never forgotten by the detectives who worked it, but without a path forward that the technology of the time could provide. 36 years passed. The world changed enormously between 1985 and 2021. The internet transformed communication and research. DNA science moved from a forensic novelty to the backbone of criminal investigation. And by the early 21st century, a new methodology had emerged that began to close cold cases that investigators had believed might never be solved. Investigative genetic genealogy. Investigative genetic genealogy combines the power of DNA analysis with the expansive databases built by companies like AncestryDNA and 23andMe, where millions of people have voluntarily submitted their genetic profiles in the interest of learning about their ancestry and finding relatives. The technique works as follows. DNA is extracted from biological evidence collected at a scene or from a victim or an unidentified individual. A genetic profile is built from that DNA. That profile is then run against publicly available genealogical databases, not the criminal databases used in traditional DNA matching, but the consumer databases where ordinary people have uploaded their DNA in search of family history information. Because DNA is inherited from biological relatives, a hit in one of these databases does not necessarily mean a direct match to the person being sought. It might mean a match to a second cousin, or a third cousin, or a more distant relative. From that match, genealogical researchers build out a family tree, using publicly available records like census data, birth certificates, marriage records, and obituaries, until they can identify a specific individual who fits the profile of the person they are looking for. They then seek a direct DNA confirmation from that individual or from biological family members. This methodology had, by the time Maine State Police cold case investigators applied it to Baby Jane Doe's case, already produced dramatic results in other investigations across the country. The most famous of those was the identification of the Golden State Killer, a serial offender in California who had evaded justice for decades and was identified in 2018 through investigative genetic genealogy. The success of that case opened the floodgates, and law enforcement agencies across the United States began applying the technique to their own cold cases with growing urgency and growing success. Maine State Police cold case investigators, working with genealogical researchers specializing in this methodology, applied it to Baby Jane Doe's case. The DNA evidence that had been preserved from the original 1985 investigation, preserved with the meticulous care that serious investigative agencies apply to biological evidence even in cases with no immediate resolution, was reanalyzed using current genetic technology. A genetic profile was built. The profile was run through the relevant databases. The genealogical research began, working outward from whatever matches appeared, building family trees, cross-referencing records, narrowing the field of potential individuals. In June of 2022, 36 years and 6 months after an infant was left to die in a gravel pit in Aroostook County, investigators had a name. Leanna Daigle, formerly known as Leanna Garrett, was identified as the biological mother of Baby Jane Doe. She was located. She was arrested. For the first time in nearly 4 decades, the woman who had given birth to that child and walked away from her in sub-zero temperatures in a secluded gravel pit in northern Maine was facing the legal consequences of what she had done on December 6, 1985. The arrest of Leanna Daigle attracted significant attention, both because of the nature of the original crime and because of the investigative methodology that had solved it. Investigative genetic genealogy cases have a particular resonance with the public because they represent something that feels almost impossible, the long arm of justice reaching across decades, using science that could not have existed when the crime was committed, to find accountability for a victim who had spent 36 years without a name or a mother identified. The community in Aroostook County and the broader Maine public responded with a mixture of grief for Baby Jane Doe and a kind of quiet satisfaction that the investigation had finally reached a conclusion. The prosecution of Leanna Daigle proceeded in Aroostook County. The original charge carried substantial weight, and the prosecution approached the case with the seriousness it warranted. As the legal process moved forward and both sides evaluated the evidence, the strength of the case, the passage of time, and the practical realities of prosecuting a crime committed 38 years earlier, a plea agreement was reached. In April of 2023, Lee and Daigle entered a guilty plea to a reduced charge of manslaughter. The court sentenced her to 6 years in prison. For many observers, that sentence, 6 years, measured against the 38 years that baby Jane Doe's identity remained unknown and measured against the life that infant was denied, felt insufficient. That reaction is understandable and deserves to be acknowledged rather than dismissed. A 6-year sentence for leaving a newborn in a frozen gravel pit does not, on its face, feel proportionate to the weight of what occurred. The legal reality, however, is genuinely more complicated than a simple comparison of sentence length to crime severity might suggest. Prosecution of crimes committed decades earlier involves a range of evidentiary, procedural, and statutory challenges that significantly constrain what a modern-day conviction and sentence can look like. Witnesses' memories have faded or witnesses have died. Physical evidence, however well-preserved, has aged. Statutes of limitations, changes in the law, and constitutional constraints on prosecution all bear on what is achievable. The plea to manslaughter and the 6-year sentence represent what the Aroostook County prosecution, exercising its professional judgment about the totality of the evidentiary situation, determined was the strongest achievable legal outcome given those constraints. What is unambiguous is this: accountability was achieved. Baby Jane Doe's story was told in open court in Aroostook County. Her mother's identity is now part of the permanent public record. The child who lay in a frozen gravel pit for 38 years without a name now has one in the court documents. And the investigative genealogy methodology that solved her case has since been applied to dozens of cold cases across the country, giving families long-denied answers and bringing justice to victims who seemed destined to remain forever unidentified. Baby Jane Doe was in this world for only the hours between her birth and the cold night that followed. She never had the chance to be known, to have a name used with love, to grow up in the St. John Valley or anywhere else. She was never given the chance to become anything. Now, at least, she is no longer unknown. And the woman who made that choice on December 6, 1985, is no longer unidentified either. If you find this kind of investigative journalism valuable, if you believe these stories deserve to be told and that these victims deserve to be remembered, please subscribe to Cold Case Hour, like this video, and share it with someone you know cares about justice. Your support is what keeps this channel alive and makes these stories possible. Case 4, Shawna Gatto, December 8, 2017, Lincoln County, Maine. When a child is placed in the care of the state's child welfare system, the foundational promise made to that child and to the community is that the placement will be safe, that the adults receiving that child into their home have been evaluated, vetted, and determined to be appropriate caregivers, that the system maintaining oversight of that placement is functional, attentive, and responsive, that someone, somewhere in the chain of responsibility, is watching, regularly, carefully, and with the child's safety as the absolute priority, and that the system, for all its acknowledged complexity and admitted imperfection, will at minimum keep the child alive. The case of 4-year-old Kendall Chick and the woman convicted of causing her death, Shawna Gatto, is not merely a story about one household and one tragedy. It is a case study in what happens when every layer of that system, the placement process, the oversight mechanism, the monitoring structure, the interagency communication, fails simultaneously and catastrophically. And in what the courts do when confronted with the full, documented weight of those failures and their consequences. Kendall Chick was 4 years old. She had been removed from her parents' care by the Maine Department of Health and Human Services, the state agency responsible for child welfare in Maine, and placed with her paternal grandfather and his fiancée, Shawna Gatto, in their home in Wiscasset, Maine. Wiscasset is the county seat of Lincoln County, located in the mid-coast region of Maine, a small town of roughly 3,500 people known primarily for its antique shops and its position on the Sheepscot River. The placement of Kendall with her grandfather and his fiancée was made through official DHHS channels, following the procedures that govern such placements under Maine law. Kendall was in that home legally, as a dependent child under state supervision. She was supposed to be safe. The entire institutional apparatus of Maine's child welfare system was supposed to ensure that she was safe. On December 8, 2017, Kendall Chick did not survive. The medical examination that followed documented injuries of a severity and distribution that immediately told investigators the same story that had emerged in other child fatality cases. This was not an accident. The injuries found in Kendall's case, injuries to her abdomen and head that investigators and the medical examiner characterized as consistent with repeated, deliberate physical harm, were not consistent with any accidental mechanism. They were not the result of a fall. They were not the result of any single event. The evidence pointed to a pattern of harm that had been inflicted in that home, on a 4-year-old child, over a period of time, a period during which the state of Maine, through its child welfare agency, had responsibility for monitoring that child's placement and ensuring her safety. Shawna Gatto was arrested and charged with depraved indifference murder in Lincoln County. The prosecution that followed built its case on the medical evidence, the investigative findings about the household and the conditions within it, and the documentation from DHHS regarding the placement process and the oversight, or the critical absence of adequate oversight, that had characterized Kendall's time in that home. The prosecution argued not merely that Gatto had caused Kendall's death, but that she had done so in a manner that met the legal standard for depraved indifference murder, conduct manifesting a profound and conscious disregard for the value of a child's life. In April of 2019, a jury in Lincoln County Superior Court convicted Shawna Gatto of depraved indifference murder in the death of Kendall Chick. The verdict followed careful deliberation. The court then proceeded to sentencing. Lincoln County Superior Court sentenced Shawna Gatto to 50 years in prison. 50 years. That is the longest sentence delivered in any of the 10 cases examined in this documentary. It is a sentence that reflects the court's careful and considered assessment of multiple factors: the severity and nature of the injuries Kendall sustained, the circumstances of her placement as a child under state protection, the deliberate pattern of harm reflected in the medical evidence, and the court's overall judgment about what accountability required in this specific case. A 50-year sentence, imposed on a woman who was not elderly at the time of sentencing, is effectively a sentence that encompasses the remainder of a person's productive life. It reflects a court that looked at what had been done to a 4-year-old child in state care and concluded that the full weight of available legal consequence was the only proportionate response. The institutional fallout from Kendall Chick's death and from the near-simultaneous emergence of the Marissa Kennedy case in Waldo County was unprecedented in recent Maine history. The conjunction of two high-profile child fatality cases within months of each other, both involving children who were in contact with or under the supervision of Maine's child welfare system, created a level of public pressure and political urgency that could not be managed through routine agency responses. Legislative hearings in the Maine legislature stretched across multiple sessions and involved testimony from child welfare advocates, former foster children and foster families, DHHS officials, pediatric medical professionals, and family law attorneys. The hearings were, at times, deeply contentious. Lawmakers from both parties demanded explanations for how a child under state supervision could be placed in a home where she would be harmed to the degree documented in the court record. The DHHS commissioner at the time faced direct, sustained, and pointed questioning. The agency's caseload management practices, staffing levels, training protocols, and interagency communication systems were all examined. The advocacy organizations that had been raising concerns about Maine's child welfare system's capacity and structural challenges for years found themselves at the center of a conversation that was now impossible to avoid. Some of those organizations had been publishing reports, testifying before legislative committees, and reaching out to journalists for years before Kendall Chick and Marissa Kennedy died. Their concerns had not produced the systemic changes they were calling for. The deaths of two children within months of each other produced a level of legislative and administrative urgency that nothing else had. Policy changes were made. Caseload caps were discussed and, in some form, implemented. Training requirements were revised. Oversight mechanisms were reviewed. The question of whether kinship placements with biological relatives of a child, like the grandfather placement in Kendall's case, received adequate scrutiny compared to placements with licensed foster families became a specific focus of reform discussions. Whether the changes made in the aftermath of these cases were sufficient, whether they were implemented with adequate consistency and accountability, and whether Maine's child welfare system today, is meaningfully better equipped to prevent the kind of tragedy that claimed Kendall Chick's life? Those are questions that advocates, journalists, and lawmakers in Maine continue to press. What is not subject to continued debate is what happened to Kendall Chick in that home in Wiscasset. The court record in Lincoln County answered that with finality and specificity. And the 50-year sentence imposed on Shawna Gatto ensures that the accountability attached to her name and to what she did to a 4-year-old child placed in her care by the state of Maine will follow her for the rest of her natural life. Kendall was 4 years old. She had been placed in a home by a system that promised to protect her. That promise was broken at the institutional level before it was broken at the household level. Both failures are part of this story, and both deserve to be named. If you have concerns about the welfare of a child in the foster care system, in a kinship placement, or in any other care arrangement, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Reports can be made anonymously. The call is free, and the information you provide could make a difference that no one else is in a position to make. Please like this video, leave a comment, and subscribe to Cold Case Hour. These stories exist because someone chose to pay attention. Be that person. Case 5, Leanna Norris, June 23, 2013, Penobscot County, Maine. There is a legal standard in criminal proceedings called the insanity defense. It is among the most carefully scrutinized, most rigorously examined, and most difficult to prove defenses in all of criminal law. Not because courts are hostile to mental health evidence, but because the standard for what constitutes a legally sufficient insanity defense is intentionally and appropriately demanding. To succeed, the defense must establish, to the satisfaction of the finder of fact, whether judge or jury, that at the time of the act, the defendant was so profoundly impaired by a diagnosed mental condition that they could not understand the nature of what they were doing, or could not understand that what they were doing was wrong. It is not sufficient to show that a defendant suffers from mental illness, or that their mental state at the time was affected by stress or emotional distress, or any of the ordinary human experiences that accompany difficult circumstances. The standard is higher, more specific, and more demanding than that. Courts apply it with rigor precisely because it is a complete defense. A successful insanity defense does not result in a reduced sentence or a lesser charge. It results in a not guilty verdict. The case of Leanna Norris, tried in Penobscot County Superior Court, is a case in which that defense was raised, evaluated by a judge with evident care, and decisively, specifically, and thoroughly rejected. Melody Grenda was 2.5 years old. She was the daughter of Leanna Norris, and she was, by June of 2013, at the center of a custody dispute between her mother and her father that had become, by any measure, deeply contentious. Custody disputes are among the most emotionally charged legal proceedings that the family court system handles. They involve the most fundamental questions of parental love, parental rights, and a child's well-being, and they occur in a context where the parties are often experiencing the dissolution of a relationship that generated enormous emotional investment and pain. Even in the most bitterly contested custody cases, cases involving allegations of unfitness, cases involving domestic conflict, cases involving profound disagreements about a child's best interests, the legal system provides a framework for resolution. Family court, attorneys, judicial evaluation of evidence. A process, however imperfect, designed to produce an outcome that protects the child's welfare. That process is where contested custody disputes are supposed to be fought and resolved. They are not supposed to end at a secluded boat launch in the rural Stetson and Newport area of Penobscot County, Maine. On June 23, 2013, Leanna Norris drove to a secluded boat launch with low melody. What followed is documented in the evidence presented at trial in Penobscot County Superior Court with a level of specificity that the court record preserves and that this documentary addresses with the care and restraint appropriate to its subject. Norris administered an intentional overdose of over-the-counter cold medication to the toddler. She then used a blanket to suffocate her. Melody Grenda, who was 2.5 years old, who was at the age when children are just beginning to put sentences together and understand the world around them, who had done nothing and could do nothing to protect herself, did not survive. Following Melody's death, Leanna Norris consumed a quantity of pills in what was characterized and documented as a suicide attempt. She survived. When law enforcement located her and the investigation into what had happened to Low Melody at that boat launch began, the evidence moved the case toward arrest and prosecution with notable speed. The circumstances were not ambiguous. The evidence was specific. Norris was arrested and charged with the intentional or knowing murder of her daughter under Maine criminal law. The decision that Leanna Norris and her legal team made in response to that charge was consequential. She waived her right to a jury trial. This is a decision that defendants in Maine, as in all American jurisdictions, are entitled to make. It is not commonly made in high-profile criminal cases where the defense has any expectation of success with a jury. Juries in child homicide cases can be moved by emotional and community dynamics that a judge is less likely to be influenced by, and defense attorneys in such cases frequently prefer to have 12 community members evaluate the evidence rather than a single judge. Norris's decision to waive a jury trial and proceed before a judge alone is significant. It suggests a legal strategy oriented around the legal and medical complexity of the insanity defense rather than around the emotional dynamics of jury persuasion. The insanity defense that Norris's attorneys mounted was thorough. They presented evidence and expert testimony in support of the position that Leanna Norris, at the time she acted on June 23, 2013, was suffering from a mental condition so severe, so all-encompassing, and so definitively impairing that the full weight of criminal responsibility should not legally attach to her conduct. Mental health professionals testified for the defense. Documentation of Norris's mental health history was introduced. The defense constructed the most complete and well-supported argument for the insanity defense that the evidence available to them allowed. The judge who presided over the case, sitting as both judge and finder of fact in the absence of a jury, evaluated that defense with the thoroughness and rigor that the legal standard demands. The judge reviewed the testimony of the mental health experts, evaluated the legal standards applicable to the insanity defense under Maine law, considered the evidence about Norris's mental state at the time of the offense, and ultimately reached a determination. The insanity defense was rejected in its entirety. The court found that the evidence presented did not meet the demanding legal standard required to excuse Leanna Norris from criminal responsibility for what she had done to Low Melody at that boat launch on June 23, 2013. The judge's rejection of the insanity defense was not a finding that Leanna Norris had no mental health issues. It was a finding that whatever her mental state was at the time, it did not reach the level of impairment that the law requires to negate criminal responsibility for intentional conduct. The distinction matters. Many people who commit serious crimes have mental health conditions. The law does not excuse criminal conduct simply because a mental health condition exists. It only excuses it when that condition was so severe that the person literally could not understand what they were doing or could not understand that it was wrong. In December of 2014, Leanna Norris was convicted of intentional or knowing murder in the death of Low Melody Grenda. The court imposed the sentence that Maine law prescribes for that conviction, life in prison. There is no parole eligibility attached to a life sentence for intentional or knowing murder in Maine. Leanna Norris will remain in a Maine correctional facility for the remainder of her natural life. The doors of the Maine Correctional Center represent the permanent horizon of her existence. There is no version of a sentence for intentional or knowing murder in Maine that offers release. The law does not provide one. The custody dispute that preceded this case, whatever its specific facts, whatever the legal positions of the parties, whatever grievances and fears and frustrations Leanna Norris may have been carrying in the months and weeks before June 23, 2013, ended in the death of a 2.5-year-old child at a secluded boat launch in Penobscot County. The family court system, whatever its shortcomings, had mechanisms available to address custody disputes. Those mechanisms were not used. A child paid for that choice with her life. The court's rejection of the insanity defense was a statement about legal responsibility and about the standards that Maine's judiciary applies when evaluating the most consequential claims a criminal defendant can make. Whatever was happening in Leanna Norris's mind on June 23, 2013, the court found that she retained the capacity to understand what she was doing and to understand that it was wrong. And what she chose to do ended Low Melody Grenda's life on the shore of a Penobscot County waterway on a June morning when her daughter had her whole life ahead of her. Low Melody was 2.5 years old. She had years and decades of life ahead of her, years that the Penobscot County Court, in its verdict, formally recognized had been taken from her. The life sentence imposed on Leanna Norris is the permanent legal record of that recognition. This is why we tell these stories. This is why Cold Case Hour exists. Not to sensationalize, not to exploit, but to remember, to inform, and to ensure that the public understands both what happened and what accountability followed. Please like this video, subscribe to this channel, and share it with someone who you think should know that these cases exist, that they were tried in court, and that Maine's legal system delivered accountability in each of them. Case 6. Ashley Malloy, November 2, 2021, Kennebec County, Maine. The intersection of the opioid crisis and child endangerment has produced some of the most legally, medically, and emotionally complex cases in Maine's recent criminal court history. Maine has, by any measure, been one of the states most severely affected by the opioid epidemic that began to accelerate across the United States in the early 2000s and reached devastating intensity in the years between 2015 and the present. The per capita rate of opioid overdose deaths in Maine has, at various points in that period, ranked among the highest in New England. Communities across the state, urban, suburban, and deeply rural, have been affected. Emergency responders in Maine have become intimately familiar with the tools and protocols for responding to overdoses. The medical examiner's office has documented the death toll in annual reports that reflect a sustained public health catastrophe. Within that larger crisis, a specific and particularly devastating subset of cases has emerged. Cases involving children whose lives have been placed at fatal risk not because of any intent to harm them, but because of the substances present in their homes and the conditions created by parental substance use disorder. These are cases that sit at the intersection of addiction medicine, child welfare law, and criminal accountability, and they challenge courts, prosecutors, defense attorneys, and communities to think carefully about how the law should respond when a child's death results from the conditions created by a parent's addiction. The case of Ashley Malloy and the death of her 14-month-old son, Carson Malloy, in Oakland, Maine, sits at precisely that intersection, with the additional dimension of a large-scale illicit drug operation that expanded the scope of the case far beyond a single household tragedy. Oakland is a small town in Kennebec County, Maine, situated a few miles from the city of Waterville on the shores of Messalonskee Lake. It is a community of several thousand people, a mix of year-round residents and seasonal visitors attracted by the lake. On November 2, 2021, emergency responders received a call reporting a medical emergency at an apartment on Oak Street in Oakland involving a very young child. First responders arrived and found Carson Malloy, who was 14 months old, in medical distress. He was transported immediately to a medical facility. Despite the efforts of the medical team, Carson did not survive. He was 14 months old. The medical examination conducted following Carson's death produced findings that directed the investigation with clarity and specificity. Carson had been exposed to fentanyl and tramadol, a combination of a powerful synthetic opioid and a semi-synthetic opioid analgesic, in concentrations that were lethal for a child of his size and age. Fentanyl, as a reference point for understanding the significance of this finding. It is a synthetic opioid that is estimated by the Centers for Disease Control and Prevention to be approximately 100 times more potent than morphine by weight. Its illicit form, often pressed into counterfeit pills or mixed into other drug supplies, has been the primary driver of overdose deaths in the United States for the past several years. Tramadol is a prescription opioid analgesic that, while less potent than fentanyl, carries significant risk of overdose, particularly when combined with other central nervous system depressants. The presence of both substances in Carson Malloy's system told investigators exactly what they needed to know about the conditions inside that Oak Street apartment. When law enforcement executed a search warrant on the apartment following the investigation of Carson's death, what they found dramatically expanded the scope of what they were dealing with. The drug operation uncovered inside was not a personal supply, not a small-scale distribution arrangement, not the kind of limited drug activity that might be associated with an individual struggling with addiction. It was, as characterized in court documents and in the subsequent legal proceedings, an illicit drug operation with an estimated value of $700,000. Multi-agency law enforcement, drawing on resources from local, state, and federal investigators, conducted what was described as a significant narcotics investigation in connection with what was found in that apartment. This was an organized, large-scale drug trafficking operation operating inside the home of a 14-month-old child. The charges filed against Ashley Malloy reflected both dimensions of what the investigation had uncovered. She faced accountability both for the loss of Carson's life and for the drug operation that had been running out of the apartment where he lived. Rather than proceeding to trial, Malloy entered a plea agreement with the prosecution. She pleaded guilty to manslaughter in connection with Carson's death, acknowledging criminal responsibility for the conditions that led to his exposure to those substances. She also pleaded guilty to 3 separate counts of aggravated drug trafficking, charges that addressed the scale and organization of the drug operation that had been discovered in the apartment. In November of 2023, Kennebec County Superior Court sentenced Ashley Malloy to 10 years in prison, with all but 4 years of that sentence suspended, followed by 6 years of probation. The structure of the sentence, with a significant suspended portion and an extended probation term, creates a framework for accountability that extends well beyond the 4 years of active incarceration. The conditions of probation imposed by the court are real and enforceable constraints. Any return to the conduct that led to Carson's death, any violation of the specific terms set by the court, carries the legal consequence of the suspended 6 years being activated and imposed in addition to whatever consequences the probation violation itself generates. The case of Carson Malloy is, in multiple respects, illustrative of one of the most persistent and devastating dimensions of Maine's opioid epidemic. The children who are not the intended targets of drug activity, who are not the customers or the clients or the participants in any part of the drug trade, but who are placed at fatal risk simply and entirely by virtue of being in proximity to it. Carson Malloy was 14 months old. He could not understand what was in that apartment. He could not recognize fentanyl or tramadol as dangerous. He could not make any choice about what he was exposed to or what he came into contact with. He was a toddler in a home, encountering his environment with the curiosity and openness that characterized children at that age, entirely dependent on the adults around him to ensure that his environment was safe. It was not safe, and the consequences were irreversible. Maine, like every state in New England, and like most of the country, has grappled intensively with the question of how to address the intersection of parental substance use disorders and child welfare. The tensions within that question are real and significant. On one hand, treating addiction primarily as a criminal matter, removing children from parents at the first sign of substance use, pursuing aggressive prosecutions, can, advocates argue, drive people away from treatment and make them less likely to seek help, which can ultimately put children at greater risk. On the other hand, a purely therapeutic response that does not attach meaningful legal accountability to situations where a child loses their life cannot adequately address the gravity of what occurred. Maine's courts and prosecutors navigate that tension case by case, and the outcomes, like the sentence in Carson Malloy's case, reflect the specific circumstances of each situation. Carson Malloy was 14 months old. He was at the age when children are just beginning to walk steadily, to explore their world with growing independence, to develop the vocabulary of their first words. He deserved the chance to keep exploring. He deserved to grow up. He deserved every ordinary, unremarkable day that the children of parents in safe households take entirely for granted. If you or someone you know is struggling with substance use and there are children in the home, help is available and the call is confidential. The SAMHSA National Helpline can be reached at 1-800-662-4357. 24 hours a day, 7 days a week. It is free. It is confidential. And it connects callers with treatment referrals, information, and support. Please like this video, hit subscribe, and leave a comment below. Cold Case Hour is here every week, telling the stories that deserve to be told, in the way they deserve to be told. Case 7, Jim Bean, February 18, 2024, Penobscot County, Maine. Not all of the cases examined in this documentary have reached their final legal resolution. In the landscape of active criminal proceedings, there are cases where accountability is already being delivered and cases where it is still being built, where the courts are still in the process of determining what sentences will follow the findings of guilt that have already been established. The case of 10-year-old Braxton Smith, who did not survive the conditions he was subjected to over a prolonged period while in the care of his mother and other adults in his household in Bangor, Maine, is one of those cases. As of the recording of this episode, the legal proceedings are in their final stages, with guilty pleas already entered by all 3 individuals charged and sentencing hearings either recently concluded or scheduled for the coming months. What has been established in court, through those guilty pleas and the documentation that accompanied them, is sufficient to understand both the full scope of what occurred in that Bangor household and the accountability that Maine's courts are now in the process of formally imposing. Bangor is the 3rd largest city in Maine and the county seat of Penobscot County. It is a city of approximately 32,000 people situated on the western bank of the Penobscot River, about 60 miles from the coast. It is a regional hub for healthcare, retail, and services for the communities of central and northern Maine. It has, like many mid-sized New England cities, experienced the full range of social challenges that the opioid epidemic and economic shifts have brought to communities across the region. Its courts handle a significant volume of criminal cases annually, and its medical facilities serve not just city residents but patients from the surrounding region. It was in one of those medical facilities that the case of Braxton Smith entered the public record on February 18, 2024. Braxton Smith was 10 years old. He was at the age when children are beginning to develop their own distinct interests, their own sense of humor, their own understanding of their place in a social world that extends beyond their immediate family. 10-year-olds have opinions. They have preferences. They have friends. They are beginning to form the identity they will carry into their teenage years and beyond. Braxton deserved every part of that developmental journey. He deserved to be known, not as a name in a court file, not as a subject in a documentary, but as a person, growing up in Bangor or wherever life might have taken him, becoming whoever he was going to be. On February 18, 2024, Braxton was transported to a Bangor hospital. He did not survive. The medical examination conducted in connection with his death produced findings that were characterized by investigators and medical professionals using the same clinical framework that appeared in several earlier cases in this documentary, battered child syndrome. The pattern of injuries documented in Braxton's case was consistent with what medical examiners and forensic pathologists recognize as the result of prolonged, repeated, deliberate harm inflicted on a child over an extended period of time. This was not a single incident. It was not an accident. The medical evidence described a child who had been subjected to systematic harm over the course of months. The investigative details that emerged from the Penobscot County investigation, and that became part of the court record through the guilty pleas and supporting documentation, paint a picture that is among the most difficult to engage with responsibly, while maintaining the standards this channel holds to regarding language, framing, and the dignity of victims and their families. What the official record establishes, through the guilty pleas and the court filings that form the documented foundation of the Penobscot County case, is this. In the months before February 18, 2024, Braxton Smith had been denied adequate nutrition. He had been physically restrained using zip ties. He had been subjected to physical harm on a repeated basis. He had been deprived of the basic conditions that any child, any human being, requires for survival and dignity. The court record describes a child who was systematically, methodically denied everything that the law and basic human decency require the adults in a child's life to provide. 3 individuals were charged in connection with what happened to Braxton Smith. Each had a distinct role in the household and in the events documented by the investigation. Each faced charges calibrated to reflect the nature and extent of their individual responsibility. Each, ultimately, entered a guilty plea, an acknowledgement before the court, under oath, of criminal responsibility for what had occurred. Jem Bean was the first to resolve her case through the legal process. Jem Bean is Braxton's mother. In February of 2026, she entered a guilty plea to manslaughter in connection with Braxton's death. That plea represents a formal, legal admission that her conduct, whether through action or through a failure to act in the face of what was happening to her son, rose to the level of criminal responsibility under Maine law. Her sentencing was scheduled to follow the plea. The cases involving the other two defendants moved on parallel tracks through the Penobscot County court system. Joshua Smith, Braxton's father, was the second defendant to resolve his case. In June of 2026, within weeks of the recording of this episode, Joshua Smith entered a guilty plea to murder in connection with Braxton's death. The charge of murder, as distinct from the manslaughter charge that Jem Bean pleaded to, reflects the prosecution's and the court's assessment of Joshua Smith's specific role and the nature of his conduct as established by the evidence. Misty Latterette, Braxton's grandmother, also entered a guilty plea in June of 2026. Her plea to manslaughter reflecting her individual level of criminal responsibility for what occurred in that household. The sentencing proceedings for these three defendants were, at the time of this recording, scheduled across late June and September of 2026. Because those proceedings have not yet fully concluded, the complete picture of the accountability that Penobscot County's courts will formally impose in this case remains to be written into the final record. What is already established, through the guilty pleas entered by all three defendants, is that the court record now contains formal, sworn admissions of responsibility. Three people have stood before a court in Penobscot County and acknowledged, through the legal mechanism of a guilty plea, their role in what happened to Braxton Smith. The sentences that follow will determine the specific terms of the accountability imposed, and they will be a matter of permanent public record. The case of Braxton Smith has attracted significant attention in Maine and beyond, not only because of the severity of what occurred, but because of the number of people involved and because of the questions it raises about how harm to a child can persist, undetected by outside institutions, over an extended period of time. How does a 10-year-old child in a city like Bangor, a city with schools, medical facilities, social services, and a broader community, experience what Braxton experienced without that experience becoming visible to someone in a position to intervene? That question has no simple answer, and it deserves more than a simple answer. It deserves sustained, serious engagement from child welfare professionals, educators, healthcare providers, and community members who understand that the visibility of harm depends entirely on people being willing to look and to act on what they see. Braxton Smith was 10 years old. He deserved every year ahead of him. He deserved the ordinary experiences that 10-year-olds deserve: school, friends, growing up, becoming himself. The proceedings now concluding in Penobscot County represent the state of Maine's formal, legal answer to what was done to him and to who was responsible. Cold Case Hour will continue to follow this case as the sentencing proceedings conclude. If you want to be notified when we cover the final resolution of the Braxton Smith case, make sure you are subscribed to this channel and have notifications turned on. Please like this video, leave a comment below, and share it. Braxton Smith's story deserves to reach as many people as possible. Case 8, Mariah Dobbins, March 19, 2022, Aroostook County, Maine. The small farming community of Easton, Maine sits in the agricultural heartland of Aroostook County, a landscape defined by vast potato fields, long winters, and the kind of community life that is characteristic of small, rural New England towns. Easton has a population of well under 2,000 people. It is the kind of place where the school knows every family, where the same last names appear on mailboxes across multiple generations, where an ambulance call to a particular address generates awareness rippling quickly through the community. On March 19, 2022, Mariah Dobbins contacted emergency services to report that her 18-month-old son, Jaden Raymond, was unresponsive at their home. The response of law enforcement and the medical investigation that followed would lead, more than a year later, to a guilty plea and a sentence in Aroostook County Superior Court that closed another chapter in the devastating intersection of Maine's opioid epidemic and child welfare. Jaden Raymond was 18 months old. 18 months is an age of extraordinary developmental activity. Children at that age are typically walking, beginning to run, learning to climb, discovering what their hands and feet can do, exploring everything within reach with the complete and uncalculating openness that characterizes very young children. They have no filter, no inhibition, no developed understanding of what is safe and what is not. They reach for everything. They put things in their mouths. They investigate their environment with a totality of engagement that is one of the most striking characteristics of that developmental stage. Jaden was doing exactly what 18-month-old children do when he encountered what investigators would later determine was the substance that ended his life. Mariah Dobbins told emergency responders that she and her children had fallen asleep watching television earlier that evening and that she had woken to find Jaden not responding normally. Emergency services transported Jaden for medical treatment. He did not survive. The autopsy conducted following Jaden's death produced findings that were specific, conclusive, and that directed the subsequent investigation with precision. The toxicological analysis confirmed that Jaden Raymond had died from a fatal fentanyl overdose. The fentanyl had not been administered to him deliberately. The investigation established that the substance had been present and accessible within the home, and that Jaden had come into contact with it in the way that toddlers come into contact with accessible substances, by encountering it in his environment and being exposed to it without any adult intervention preventing that exposure. The finding of fentanyl in Jaden Raymond's system and the investigative determination that it had been accessible in the home raised the central legal question of the case. What level of criminal responsibility attaches to a parent whose child dies because illegal drugs are accessible in the home? That question is one that Maine prosecutors and courts have grappled with repeatedly in the context of the opioid epidemic, and the answers have not been uniform. In some cases, the charge has been murder, on the theory that leaving a lethal substance accessible to a young child demonstrates the kind of reckless disregard for human life that supports a murder charge. In others, manslaughter, acknowledging criminal negligence without the heightened culpability element required for murder. The initial charge in Jaden Raymond's case was murder. As the case moved through Aroostook County Superior Court, the prosecution and defense reached a resolution through negotiation. Mariah Dobbins entered a guilty plea to manslaughter, a formal acknowledgement before the court that her conduct in allowing fentanyl to be accessible in a home where an 18-month-old child lived amounted to criminal negligence resulting in death. The guilty plea resolved the case without a trial, bringing the legal proceedings to a conclusion while preserving the formal record of accountability. In July of 2023, Aroostook County Superior Court sentenced Mariah Dobbins to 12 years in prison, with all but 4 years suspended, followed by 6 years of probation. The structure: 4 years of active incarceration, 8 years of suspended time, and 6 years of probation, creates a framework of accountability that extends well beyond the period of active incarceration and ensures that Dobbins's conduct and circumstances will remain subject to formal court oversight for a significant period following her release. The conditions attached to probation are real and binding constraints. Any conduct that violates those conditions, any return to the circumstances that led to Jaden's death, can trigger the imposition of the suspended portion of the sentence. Comparing the sentence in Jaden Raymond's case to others in this documentary is instructive. The 4 years of active time and the 12-year total sentence are consistent with the sentence structure imposed in the Ashley Malloy case from Kennebec County, though the specific charges differed. Both cases involved the death of a very young child from opioid exposure. Both resulted in manslaughter pleas. Both resulted in sentences with significant suspended components and extended probation. The consistency suggests that Maine courts have developed, through practice and precedent, a general framework for these cases, though each case is ultimately evaluated on its own specific facts and circumstances. The community of Easton and the broader Aroostook County community experienced this case with the particular weight that such cases carry in small, close-knit communities. When a child dies in a small town, the grief is communal. People knew the family, or knew people who knew them. The school, the church, the local businesses. All of these community institutions feel the loss in ways that are different from how urban communities, with their greater anonymity, process similar tragedies. The legal outcome in Aroostook County, the guilty plea, the sentence, the formal record, is the community's permanent documentation that what happened to Jaden Raymond was not acceptable, was not overlooked, and was not excused. Jaden Raymond was 18 months old. He was in his home, exploring his world the way 18-month-olds do, when he encountered something that had no business being accessible to him. The 4 years that Mariah Dobbins will serve in a Maine correctional facility and the years of supervised probation that follow are the legal system's formal answer to the circumstances of Jaden's death. He is remembered here. He is remembered in the Aroostook County court record. He deserves to be remembered. If someone in your life is struggling with opioid use and there are children in the home, the SAMHSA National Helpline at 1-800-662-4357 is a free, confidential resource available around the clock. That call can be the first step toward a different outcome. Please like this video, share it, and subscribe to Cold Case Hour. Your support is what allows this channel to keep bringing these stories to light. Case 9, Hillary Goading, June 4, 2021, Penobscot County, Maine. There is a moment in the Hillary Goading case, a moment documented in the investigative record and discussed in the court proceedings that concluded in Penobscot County Superior Court in September of 2022, that investigators, child welfare professionals, medical responders, and legal commentators have returned to again and again in the years since the case was resolved. It is not the moment when 3-year-old Haley Goading was exposed to the substance that would ultimately end her life. As devastating as that exposure was, it occurred in the context of a pattern of circumstances that, while criminally negligent, is unfortunately not without precedent in the landscape of Maine's opioid epidemic. What makes this case different? What elevates it in the assessment of investigators, and what drove the court to impose a significantly more severe sentence than those given in comparable cases, is not the moment of exposure. It is the moment that came after. It is the hours that followed. It is the decision that Hillary Goading made when she recognized that something was wrong with her daughter and chose, deliberately and knowingly, not to call for help. That choice, and the more than 24 hours of inaction that constituted it, are at the center of what the court in Penobscot County was asked to evaluate when Hillary Goading entered her guilty plea. They are the element that distinguishes this case from the Malloy and Dobbins cases that precede it in this documentary. Cases where children died because substances were accessible in homes, where the parents did not anticipate the exposure and did not have a moment of recognition and decision after it occurred. In Hillary Goading's case, there was a moment of recognition. There was an opportunity to act. And the decision made in that moment, not to act, not to call, not to seek help because of what seeking help might mean, is what the Penobscot County Court treated as the defining element of the criminal accountability that followed. Haley Goading was 3 years old. She lived with her mother, Hillary Goading, in Old Town, Maine, a city of approximately 8,000 people in Penobscot County, situated on the western bank of the Penobscot River about 8 miles north of Bangor. Old Town is home to the University of Maine at Old Town's neighboring campus at Orono, and it is a community that has experienced the full range of social and economic challenges facing small Maine cities, including the devastating impact of the opioid epidemic. On June 4, 2021, Haley came into contact with a plastic drug straw, a small piece of paraphernalia that had been used by her mother and that contained residue from a mixture of fentanyl and heroin. 3-year-old children explore the world through touch and through their mouths. They pick things up. They investigate objects with their hands and their senses. They have no ability to assess the danger of what they encounter. Haley encountered that straw the way any 3-year-old would encounter an accessible object in her home, without any awareness of what it was or what it contained. The exposure was sufficient to trigger a medical emergency. Haley's breathing became labored and irregular, what the court record describes as heavily raspy and visibly distressed. Something was wrong. The visible and audible change in Haley's breathing was the kind of sign that any parent would recognize as requiring immediate medical attention. Hillary Goading saw it. She heard it. She knew that her daughter's condition was not normal. She did not call emergency services. The reason for that decision, a reason that investigators established through the investigation and that was incorporated into the court record, was fear. Specifically, fear of what would happen if law enforcement became involved. Fear of what would be found in the home. Fear of the consequences of having drug paraphernalia present and accessible in a home with a 3-year-old child. That fear, and the calculation it produced, the calculation that the risk of police involvement outweighed the risk of waiting, held Hillary Goading in place while Haley's condition worsened over the hours that followed. She waited for more than 24 hours. During those hours, Haley Goading's condition deteriorated. Her body was responding to the opioid exposure in the way that a small child's body responds, with the progressive respiratory depression that is the mechanism of opioid toxicity and overdose, a mechanism that, in children, operates with particular severity because of the dose-to-body weight relationship that makes even small amounts of a potent opioid potentially lethal. Each hour that passed without medical intervention was an hour in which whatever chance Haley had of survival was diminishing. Each hour that passed was an hour in which the window for treatment, for the administration of naloxone, for the medical interventions that can reverse opioid toxicity if administered in time, was narrowing toward closure. Haley Golding died on June 6, 2021, 2 days after the exposure that had put her in medical danger. The medical examiner's findings confirmed the cause of death as opioid toxicity, specifically attributable to the fentanyl and heroin exposure. The investigation that followed moved to Haley Golding quickly and with the specificity that the evidence demanded. The documented gap, more than 24 hours between when Haley's distress became visible and audible and when emergency services were finally contacted, was established through the investigation and became the cornerstone of the prosecution's case. Haley Golding was charged and prosecuted in Penobscot County. In September of 2022, she entered a guilty plea to manslaughter. The guilty plea was the legal mechanism by which she acknowledged criminal responsibility for Haley's death, not through the theory that the initial exposure was itself criminal in the same way as deliberate harm, but through the theory that her decision to wait, to not seek help, to let more than a full day pass while her 3-year-old daughter's condition worsened and became irreversible, constituted criminal conduct under Maine law. The court sentenced Haley Golding to 19 years in prison, with all but 17 years suspended. 17 years of active incarceration. That sentence is dramatically more severe than the sentences imposed in the Malloy and Dobbins cases, 4 years of active time each. And the reason for the disparity is clear in the court record and in the analysis that any careful observer of these cases would arrive at independently. The Malloy and Dobbins cases involved accidental exposure, situations where a child encountered a substance because it was present and accessible, without any moment in which the parent had the opportunity to prevent the death and chose not to. In Haley Golding's case, there was that moment. There was more than 24 hours of moments. And in every one of those moments, the decision was made not to call for help. The 17 years of active incarceration that Haley Golding will serve are the court's direct response to that decision, to the recognition that the death could have been prevented, that the window for prevention was open for more than a full day, and that it was closed not by circumstances outside anyone's control, but by a deliberate choice. For child welfare advocates and medical professionals who engage with cases of this kind, the Golding case has particular educational significance. It illustrates, with a clarity that the court record makes impossible to misinterpret, the medical and legal consequences of delayed emergency response in pediatric opioid exposure situations. Naloxone, commonly known by the brand name Narcan, is widely available in Maine, including at pharmacies without a prescription, and it can reverse opioid overdose effects if administered quickly enough. The Maine Opioid Response Program and various public health initiatives have worked to make naloxone accessible across the state precisely because of the time sensitivity of opioid overdose situations. Every hour that passes in an untreated opioid overdose is an hour that may not be recoverable. Haley Golding was 3 years old. She found something on the floor of her home that she did not understand, that she could not have understood, that she had no ability to protect herself from. She needed her mother to protect her, and in the hours when that protection mattered most, when it might have made a difference, she did not receive it. The 17 years that Haley Golding will serve in a Maine correctional facility are the legal answer to that failure. They do not bring Haley back. They do not restore what was taken from her. But they are a statement, clear, specific, and lasting, about the weight of the decision that was made in those hours between June 4th and June 6th, 2021. Penobscot County's courts ensured that the legal record reflects exactly what happened and exactly what the consequences were. Haley is remembered here, in this documentary, and in the court documents that carry her name as part of the permanent record of what occurred and how the legal system responded. If you are a parent or caregiver who is struggling with substance use, please seek help before a situation like this one becomes irreversible in your life. The SAMHSA National Helpline at 1-800-662-4357 is free, confidential, and available 24 hours a day. Please make that call. Your child's life may depend on it. Please like this video, leave a comment below, and subscribe to Cold Case Hour. We tell these stories because these children deserve to be more than a case number. Case 10, Darlene George, June 20th, 2008, York County, Maine. Every case documented in this episode of Cold Case Hour has involved the death of a child. 9 cases in which the victims were the smallest, most developmentally vulnerable members of the households where these events occurred. Children ranging from a newborn who never received a name to a 10-year-old boy who had a decade of life behind him when it was cut short. Those 9 cases share certain characteristics that link them in theme and in the specific questions they raise about child safety, institutional responsibility, and the legal accountability that follows when harm reaches its most devastating conclusion. Case 10 is different. The victim in this case was an adult. He was a husband. He was a father. He was a man who was, by the summer of 2008, navigating the end of his marriage and the legal proceedings that accompany the dissolution of a shared life. The crime committed against him was not the product of a moment of rage or emotional overwhelm. It was premeditated, planned with deliberation, executed through coordination, and concealed through staging, in a way that distinguishes it categorically from every other case in this documentary. And the presence of a young child in the home during the commission of that crime, a child who survived, but who was there, who was in that house on the night his father did not survive, gives this case a dimension that belongs in a documentary examining the full range of what Maine's courts have been asked to confront and respond to. York County is the southernmost county in Maine, bordering New Hampshire to the west and the Atlantic Ocean to the east. It encompasses communities that range from small inland towns to the coastal communities that define Maine's identity in the public imagination. Old Orchard Beach is one of those coastal communities, a town of approximately 8,000 permanent residents on the southern Maine coast, known for its wide sandy beach, its seasonal amusement pier, and the distinctive character of a New England beach town that draws substantial summer tourism while maintaining a year-round community life that is separate from and often at tension with the seasonal economy. It is not the kind of community that typically becomes the scene of the kind of premeditated, coordinated criminal conduct that unfolded there on June 20th, 2008. Darlene George and Winston George were married. Their marriage, by the time the summer of 2008 arrived, was ending. They shared property, real estate, and other assets that had been accumulated over the course of the marriage and that were, under Maine's equitable distribution laws for divorce, subject to division by a family court. The prospect of that division, the reality that the properties that Darlene George may have considered primarily hers, or that she had particular plans for, would be subject to a court-supervised distribution process that could direct a significant portion of that value to Winston George, appears, based on the evidence presented in the subsequent criminal trial, to have been the motivating factor in what followed. Divorce is hard. The financial dimensions of divorce, the division of assets that both parties may have strong feelings about, the process of separating a shared economic life that may have been built over many years, can generate conflict that feels catastrophic to the people experiencing it. But the legal system provides a framework for navigating that conflict. Attorneys, mediation, family court proceedings, a judicial process, however imperfect and however emotionally costly, designed to produce an outcome that is fair, documented, and enforceable. That process was available to Darlene George. She chose a different path. The plan that Darlene George developed, and the evidence presented at trial in York County Superior Court established that it was a plan, deliberate and coordinated, involved 2 other people. The first was her brother, Jeffrey Williams. The second was described in court records as her secret romantic partner, Rennie Cassimy. The plan was straightforward in its criminal logic, however devastating in its human consequences. Winston George would be killed before the divorce could be finalized. The properties would not be divided. The outcome that Darlene George had decided was unacceptable, her husband receiving a share of what they had built together, would not occur. On June 20th, 2008, the plan was carried out. Winston George was at home. His young son was also in the home that night, a fact that would become part of the evidence record and part of the community's response to what had occurred. Jeffrey Williams and Rennie Cassimy entered the residence. Winston George did not survive. The investigation conducted by York County law enforcement and Maine State Police detectives would later establish the full picture of what had occurred and who was responsible. What came next was a deliberate and organized effort to conceal what had happened. Darlene George participated in staging the scene, working to create the appearance that the home had been the target of a violent, random home invasion robbery. The staging was designed to direct investigators away from the truth and toward a false narrative. That unknown intruders had entered the George home, that the incident was a robbery that had turned fatal, that the people responsible were strangers with no connection to the family. The staging included elements designed to be consistent with a home invasion robbery, a crime type that investigators understand well and that carries a specific physical signature. It did not work. The investigators who worked the scene and the subsequent investigation were not deflected by the staged elements. Forensic examination of the scene, the pattern of evidence, the physical details of what had actually occurred in that home, and the investigative work that followed, interviews, documentary evidence, witness accounts, and the painstaking reconstruction of events that serious homicide investigators conduct, told a different story than the staging was designed to suggest. The investigation moved through its stages methodically, and the picture that emerged pointed, with increasing clarity and specificity, to Darlene George. Darlene George was arrested and charged with intentional or knowing murder and with conspiracy to commit murder. The conspiracy charge is legally and factually significant. Under Maine law, a conspiracy charge requires proof of an agreement between two or more people to commit a criminal act and a deliberate act in furtherance of that agreement. The presence of both charges, murder and conspiracy, in the indictment was a formal statement by the prosecution that this was not an impulsive act but a coordinated criminal enterprise, a planned killing, involving multiple participants, organized and executed with deliberation. York County Superior Court conducted the trial. The prosecution presented its case, the forensic evidence from the scene, the investigative findings that traced the plan and its execution, the evidence that established the roles of the three participants. The defense challenged the evidence and argued for a different interpretation. The jury, having heard all of it, returned its verdict. Darlene George was convicted on both counts, intentional or knowing murder and conspiracy to commit murder. The court sentenced her to 40 years in prison. 40 years represents a sentence that will encompass the entirety of whatever remains of Darlene George's productive life. She was not elderly at the time of sentencing. 40 years means she will be a very old woman, if she survives at all, before she is eligible for any form of release. Her brother, Jeffrey Williams, one of the individuals who physically entered the home and participated directly in what occurred there on June 20, 2008, received a life sentence from the York County Court. The differentiation in sentencing between Darlene George's 40 years and her brother's life sentence reflects the court's individualized assessment of the roles each person played, the specific criminal conduct each was found guilty of, and the legal standards applicable to each defendant's situation. A life sentence, in Maine, means exactly what it says. Jeffrey Williams will remain incarcerated for the remainder of his natural life. Rennie Cassimy, the third participant, Darlene George's secret romantic partner, who was also brought into the plan, was also prosecuted in connection with Winston George's death and faced the legal consequences of his participation. The young son who was in that home on the night of June 20, 2008, is not named in this documentary, and his identity is not appropriate for public discussion in this context. He was a child. He was present during or in the immediate aftermath of events that no child should ever be proximate to. Whatever his life has looked like in the nearly 2 decades since that night, whatever support he received, whatever path he found, whatever he has made of the years that have passed, the hope attached to his story, from every person who hears this case, is that he found his way towards safety and toward the life he deserved. He is not forgotten. He is simply protected, as children in these circumstances deserve to be protected, from being identified and discussed publicly in connection with a crime that was done to his family, not by him. Winston George did not make it out of his home on the night of June 20, 2008. He was not a child. He was a man, a husband, a father, an adult navigating the end of his marriage through the legal channels available to him, whose life was taken by people who had decided, with premeditation and deliberation, that his continued existence was an inconvenience they were not willing to tolerate. His death was not an accident. It was not a moment of uncontrolled emotion. It was a plan, executed by 3 people who made a choice and then tried to hide what they had done. York County's courts responded with the full, unambiguous weight of Maine's criminal law. The 40-year sentence imposed on Darlene George, combined with the life sentence given to her brother, represents a judicial system that looked at what happened in that house in Old Orchard Beach, looked at the planning, the coordination, the execution, the staging, the deliberate effort to deceive the investigation, and concluded that the maximum accountability available under law was the only proportionate response. This is why courts exist. This is why the investigative process matters. This is why the documentation of these cases, in courtrooms, in public records, and in documentaries like this one, serves a purpose that extends beyond simply recounting what went wrong. It is a record. It is accountability. It is the community saying, through the formal mechanisms of the legal system, we saw this, we documented it, we prosecuted it, and we will not allow it to pass without consequence.